So, good afternoon, everyone. It is a great pleasure for me to open this webinar, which is part of the Max Planck lecture series of the Max Planck Institute, Luxembourg for Procedural Law. I have the immense pleasure to welcome to this webinar our two lecturers, Professor Martins Paparinskis and Professor Anne van Aaken, whom I'm going to introduce briefly before launching the discussion. But I would also like to welcome all our attendees for this first webinar of the summer. We have decided to set up this webinar to discuss an article written by Martins Paparinskis, a case against crippling compensation in international law of state responsibility. This article was published by the Modern Law Review in 2020, and it immediately attracted a lot of interest, a lot of comments, and triggered a lot of discussion. And indeed, Martins in this article raises a very interesting question, to say the least, and decided to make a case, which is a very interesting approach. And when we discussed this internally at the Max Planck Institute, and then we had the opportunity to have Martins with us to discuss his article, which is a great privilege. I'm grateful for his availability, because it's a very busy period for him. Martins is reader in public international law at University College London. So of course he has all the teaching and research obligation that any academic has in these specific circumstances, but he has also a lot of activities beside. He is a co-editor of Current Legal Problems, is the book review editor for the Journal of World Investment and Trade, which is close to the heart of the Max Planck Institute, Luxembourg. He is a member of UCL Press editorial board, but he is also, and notably because I hope I can say that, Martins, you allow me to say that from my seniority, because you're still very young, and nevertheless you're a member of the Permanent Court of Arbitration. You're a member of the Court of Conciliation and Arbitration of the OSCE, the Organization for Security and Cooperation in Europe. You're on the list on the panels of arbitrators and on the panels of conciliators for ICSID, and you're a member of the Implementation Committee of the Innes Water Convention. So it's quite an impressive curriculum. And on top of that, currently you're a candidate co-nominated by Latvia, Estonia, and Lithuania for election to the International Law Commission in 2021. And I have no doubt that the ILC would very much welcome a member like you, who has published and spoken on foundational topics of public international law, such as sources of international law, to which we know the ILC pays a lot of attention these days, law of treaties, state responsibility, and we are going to speak about that more today, international dispute settlement, territorial title, as well as topics on the subfields of international investment law, international human rights law, international environmental law, and international law of the sea. But I think that any reader of your article on a case against crippling compensation is very aware of the span of your interest and competences. And so to discuss this, we needed a strong discussant, if you allow me this, someone able to comment and maybe I say challenge you, but it is the idea is to have a nice conversation around your article. And so Anne van Aaken, who is currently Alexander von Humboldt Professor of Law and Economics, Legal Theory, Public International and European Law at the University of Hamburg, is the ideal discussant. And yet this very impressive title does not pay tribute to the range of her interests. I could also speak about your works about behavioral theories, about psychology and law. And if I would like to summarize the span of your interest, I would say that you're very much in interdisciplinary research at a level which is very unusual in our field, and for lawyers, most of whom tend to remain in the pure field of law. So this originality in your profile made also you the ideal discussant to the very rich article by Martins. You were, but your activities did not stop there. Like for Martins, you were Vice President of the European Society of International Law, and you're currently the chair of the Research Council of the European University Institute. And you are co-editor of the Journal of International Dispute Settlement. You're a member of the editorial board of several very prestigious journals, like the American Journal of International Law, the European Journal of International Law, or International Theory. And on top of that, you also have some involvement in practice as a consultant. You have been consultant for the International Bank for Reconstruction and Development, for the OECD, for UNCTAD, and for the German Agency for International Cooperation for Development. So again, a wide range of interest appears in your involvement as consultant. So I think we will have a very high level and at the same time a stimulating discussion. I have to say that to my knowledge, I have not read everything, of course, but you were the first, Martins, to write like you did on crippling compensation. And I think like many people who are not native speakers, I had to dig a bit in order to grasp the idea better. And your article is really impressive in many regards. So before giving you the floor to explain more in depth what your case is against crippling compensation in international law of state responsibility, I would like to ask you where and when you found the idea to write this article. What triggered your interest for this topic and decided you to write it, and maybe how your ideas have evolved to reach the moment where you decide to make a case?
Well, let me begin by thanking for an extraordinarily gracious and kind words of introduction. It's such a privilege to be here, even if virtually in the Max Planck Institute. It's such a privilege and pleasure, and great anticipation to have such an excellent and learned discussant on whom I have also drawn in framing the paper. So it's really, there could be no better place to discuss the paper. I think one theme that I have tried to follow in this paper is to be very honest and upfront about the intellectual pedigree, about the framing, about what I agree with, what I disagree with, and what the implications would be. And I think I'm, in a way, almost equally upfront about how the idea came to me. And it really is the first paragraph of the article is pretty much a loosely biographical write-up of the idea. I was spending my sabbatical in Bologna and having a nice Italian espresso on the morning of 8th of March. 2 years ago, so possibly thinking a little bit of Rosa Luxemburg and Clara Zetkin and Alexandra Kollontai as one should on such a day, but in particular, one email that dropped in and that I probably one shouldn't check email during the breakfast coffee, but the thing that had dropped in was an email from the wonderful Investment Arbitration Reporter website. And they have the habit of sending a compendium of all the news that they have managed to find. And one thing that came up was that the long-awaited, extraordinarily contentious case in ConocoPhillips and Venezuela had been decided. And I think that at that point, the fact that the award was for $8 billion was known, but the award itself, the text was released a few days later. So that was like sort of the one thing that popped up. The second was my morning newspaper, and I must confess that on my newspaper consumption, I'm fairly cheap, and I have a strong preference for things that do not require a paywall, which results in me usually reading The Guardian. And one of the things that was popping up on The Guardian front page was also a news item from Venezuela, from a very different context, where the reporter was explaining how lights had literally gone out in Venezuela. That there was no electricity supply, how the country had gone dark. In a few days when the award came out, I was interested to see, because it seemed like a formidable intellectual question, whether international law says something about these two circumstances, the extraordinarily large damages award on the one hand, and what seems to be the incapacity of Venezuela to provide the basic public goods, even without thinking about the $8 billion award. And so one thing that came out rather quickly from reading the award was that there was no mention at all of the extraordinary circumstances in which Venezuela found itself. I think by that point, there were already a few years of economic downturn, and as international lawyers will all know, great political controversy regarding the government. So I think I just was really struck by the fact that, perhaps at first that the tribunal did not consider it, but then perhaps even more strongly by the fact that Venezuela did not consider it as a legally relevant consideration. This was not something that Venezuela had raised and that the tribunal had rejected, but something that did not appear at all. So in a sense, it seemed like it was such an outlandish proposition that it wasn't even raised as an argument. And that was sort of probably where I tried to articulate and find whether there was something about my perhaps a slight sense of incongruity, the normative unease of the situation. Is that surely an irrelevant consideration? Try just to chase it through the formal legal process, try to see what it was that international law said on it. And then, as the article shows, so probably the second fascinating thing was that this was not a first impression, that International Law Commission had looked at it in great detail. The leading mind on state responsibility, the very much missed Judge Crawford, had addressed it directly and very sharply and clearly, as is usually the case, but international law had appeared in a slightly different direction. So I think it took me quite a bit of time just to put it all together in my mind, how the bigger systemic assumptions, the perhaps sometimes slight boringness of the formalist legal process, bigger normative pictures fit together. And I suppose, again, as I said in the beginning, I was trying to be quite, I think perhaps in a sense, reflect my own intellectual puzzlement and journey in the article to be quite clear about things that are interesting, unusual, puzzling, and at the same time endorsed by the legal process, and at the same time perhaps the broader grain of the legal process, which suggests that some things that are surprising may be germs of possible change in a direction that would strike an observer as less surprising. That's probably slightly bumbling, but an answer to your question.
Thank you very much. In fact, it was, but I think it's always very interesting to have some insights about the context, and because as you said, the problem has already been briefly considered, and yet it was not really discussed. To my knowledge, you were the first one to dedicate an in-depth study to that. So, and you say, yeah, it was only in 2020 that we got an in-depth study on that. Why is it so? And but at the same time, cheers for having found such this original idea, and it's good to have this type of articles. So what I can do now is invite you to explain more precisely what your case is.
Thank you again, and it's not quite to the point, but I wonder whether just really reflecting about the first when I was doing my master's in Oxford now a few years ago. I remember how the teacher who was to be my doctoral supervisor, Von Low, introduced the CME and Czech Republic case by saying that that is a case that had a particular relevance for him, because that was the largest case that the state had ever lost, and the largest case in which he had appeared as an international law expert for the state. But of course, from the contemporary perspective, the less than $500 million of dollars in those times now seems a charmingly quaint sum. I think I would probably take about 15 minutes or so, because I think I would like to be as brief as possible to leave as much time as possible for the discussion, to introduce the issue, to make the legal argument, consider the implications, and then, as I appreciate that there are many of the international lawyers of the future generations in the audience, perhaps some things, as ever in research, that struck me as very interesting, but that are perhaps not directly developed in this article, but that are nevertheless of interest for the broader international law discussion. As international lawyers often do, I suggest that we start with a very simplified analogy taken from domestic law. Let us imagine a private person, Bob, who destroys a priceless work of art owned by Jane. Priceless, but also capable of evaluating in monetary terms. Let's say that the value is €1 billion. Let us also assume that under the tort or delict law of the particular legal order, no particular issues arise. So there is a relevant breach, loss, causality, no circumstances precluding wrongfulness or affecting content of responsibility like mitigation apply. Now, I think it is a plausible assumption, if we throw our minds to the legal systems that we are familiar with domestically, that the protection of interests of Bob, at least to some minimal extent, would be reflected in the system. And it can be reflected in many ways. It is something perhaps that would be taken into account at the level of enforcement. It is something that might be affected at the level of bankruptcy law or judicial procedure. There may be human rights obligations that, for example, preclude imprisonment for debt and so on. There are ways of addressing these issues in various ways. Most domestic legal orders, I would imagine, recognize that unlimited compensation, even if that would be an accurate reflection of the tort delict law, is not legally sustainable. Now, the question is about the way how public international law, moving in the most early Hirsch-Lauterbach type of way of analogizing individuals with states, would address the question. That is not merely a hypothetical, outlandish case study. There are actual examples. So we have discussed the ConocoPhillips and Venezuela as one example, and investment arbitration certainly is a field that has quite a few of such cases. There's one follow-up article that I have forthcoming with ICSID Review, where in one of the early footnotes, I make the point that these claims have become routine. And so I just had when I started writing it in January, had a link to Investment Arbitration Reporter website of all the entries where the word billion appeared. So $1 billion claim accepted, rejected, set aside, notified. I think now I'm about at around, it's one of those horrifically looking American law review type footnotes, where it now takes 3/4 of the page. I mean, admittedly, it's partly because Investment Arbitration Reporter has very long titles, but I think there are probably about 15-ish, 20-ish entries now in the first half of the year. Ukraine and Colombia successfully defended multi-billion claims. Germany is about to settle a multi-billion claim. Venezuela lost their set aside in Paris. Russia won a set aside. These are things that are perfectly routine. But they are not limited to investment arbitration. In the classic interstate setting, at the end of April, the International Court of Justice heard the case at the reparation stage related to the armed activities on the territory of the Congo, where Congo asked for compensation of more than $13 billion, and Uganda argued on many, many points, but also including on the point of crippling compensation, noting that it would simply be unsustainable for Uganda itself and also for the important regional work that it was doing. And it is also something that is increasingly prominent in human rights setting, both in the Council of Europe setting, but also elsewhere. And I think that there are interesting developments in the inter-American context in particular, where the Inter-American Court has in recent years developed judicially broad concepts of socially enforceable social rights, something that, of course, in the Council of Europe setting would not be subject to the European Court, but rather to the Social Charter, which is a much more lighter touch body. And in that setting, states are increasingly reflecting on whether there may be similar concerns raised. So late last year, Chile also raised the question in a pending case, Profesores de General y otras municipalidades against Chile. So that, I think, is one interesting point that has happened since I wrote the article. The argument seems to be getting into the international law bloodstream. Right, so there's a question, there's a puzzle. What does international law say on it? Here, analytically speaking, I think as public international lawyers, we would say that the similarity between ConocoPhillips, Congo and Uganda, and academics of the General municipalities and others is that they are all going to the same legal rule. The secondary rules of state responsibility relating to content of responsibility, pursuing Roberto Ago's revolutionary conceptual transformation as being, at least in principle, the same for all types of breaches of primary rules. So raising the same questions. And the answers, going back to the International Law Commission's work on the topic that culminated in the 2001 ILC articles and addressed these matters in part 2. So part 1, the Internationally Wrongful Act itself, attribution, breach, circumstance precluding wrongfulness. Part 3, implementation, so invocation, diplomatic protection, countermeasures, and then we have part 2. So I think it's perhaps really like the poor cousin of the 3 parts, much less exciting than the other 2. So how did the International Law Commission look at it? And there's a long and interesting story, but the core of it is in Judge Crawford's 3rd report of 2000. And Judge Crawford addressed the question squarely, and I think that is one of the great intellectual pleasures of working on it, of really going back to the debates 20 years ago and just really appreciating the incredible sharpness of mind and discussion in those settings. There is no anachronistic bit of us being much smarter and appreciating things that are going on Clearly, that is international law at its sharpest. So Judge Crawford had three assumptions. First, he said, it's not obvious that it is a big issue at all. It's not often that such large claims arise that would cause significant problems for states to satisfy. And he was looking mostly at intra-American and European human rights cases. And secondly, even when these claims might arise, there are a great deal of legal and political ways of dealing with them. First, and I think, again, exemplifying his very pragmatic view, is that there's an important injunction of not being stupid, something that should not be ignored ever in international law. And that was, in Judge Crawford's view, the takeaway that states had taken from Versailles. That you can, of course, impose crippling compensations, but then you might not find yourself in the place where you would like to be in 20 years. So the very Keynesian economic consequences of peace, obviously, something that historians are debating, but within the International Law Commission, something that was really shared by people from Tomoshat to Lukashuk, from ILC members from countries who know something about the Second World War. So if you don't have crippling compensation as out of the Second World War, that is more likely to lead to a good outcome. And also, we could trust in 1990s the fundamental political wisdom of the international community. United Nations Compensation Commission, dealing with claims against Iraq, has explicit caps provided in Security Council resolutions. And so possibly you could also tweak something around circumstance precluding wrongfulness. So for Judge Crawford, if you take together the overall trivial claims, political wisdom of individual states and international community, plus legal tweaks around the edges, you don't really need a general limitation against crippling compensation. Now, the interesting point is that almost nothing of that reflects the contemporary dynamic. We do have states that bring these very large claims. Eritrea, Ethiopia Claims Commission dealt with that, the Congo-Uganda ICJ case. We have non-state actors who are not repeat players, therefore are not majorly impressed by references to Versailles and Keynes. And it's not obvious that the tweaks and exceptions like circumstance precluding wrongfulness work. So that was, I suppose, really the claim of the 1990s. It was thought of, it was decided, it was not an afterthought, but the assumptions do not really track the world where we are. And yet, and that was really the almost, in some ways, the opposite point to the first one, and yet, even though one might think that in the normal lawmaking process, states would say, well, it doesn't seem to work. We should be arguing against it. We should be trying to change it. The one thing that struck me as most interesting is really the almost full silence for the 20 years after 2001. That you would sort of, again, I hugely simplified, you would imagine that in case like Konoko versus Phillips, somebody is asked, could you please write an A4 page of arguments that are being made against us that we could make? A multi-billion claim is possibly something we should take quite seriously. One would imagine that at some point somebody will say, well, couldn't we argue that we simply could not satisfy these considerations? All these use cogents here and there and international human rights, surely that would be relevant. And these arguments are not made. They are not made by Venezuela, Ecuador, Egypt, Pakistan, other countries. And there are other settings, again, where one might say, well, if there was a colorable legal claim, somebody would have made it. And it doesn't seem to, sort of trying to look in all these places, it doesn't seem to come up anywhere. And so I think that was sort of my lawyerly conclusion of between my normative puzzlement of these things do not quite fit together. And then I suppose my formalist insight of saying, well, in the decentralized legal process, the way how we determine whether things fit or not fit together is, at the end of the day, the views of actors. You know, if it is extremely undesirable, if the state of affairs is extremely undesirable, perhaps we can be charitable in applying the rules on sources. Perhaps we could say that there are specially affected states. Perhaps we could read it against the broader background of general principles or sustainable development goals. But and I think that this was sort of the, perhaps King Lear is not the greatest authority on political wisdom, but I think the sort of one of the initial conversations that he had with his daughters, where the youngest daughter, Cornelia, refused to praise him. And he said that nothing will come of nothing. And that was sort of probably my sense as well. No matter how charitably we read the international law tapestry, if states do not have enough of a legal confidence in a claim to present it when they are faced with multi-billion claims, international legal process is not coming out in favor of them. So that is where I arrived. Now, what are the implications? And I think so the threefold implication was that we could look at it in three ways. One is that despite the assumptions having shifted, Judge Crawford's judgment has been widely endorsed by international law. Perhaps this is something that can simply be taken into account as a starting point for a negotiated settlement. And in fact, in some of the very largest claims, that is what has happened in some of the claims against Ecuador and Egypt, for example. Perhaps the right takeaway is that we should really be thinking not about the level of general secondary rules, but trying to come up with a rule that would be suitable, that would do justice to ConocoPhillips and Congo and Uganda and the professors of General simultaneously, but rather go in a specialist way, look at what each institution, what each regime says, think about rules on protection, possibly caps, possibly limitations, possibly institutions that do not fully implement responsibility. So in a way, go small rather than large. Or finally, possibly we could think about this being the right way where the incongruity of the lack of an exception to crippling compensation is such that we can slightly develop international law on the topic, that we can introduce an exception that recognizes the important community interest of the international community in not destroying states as its basic building blocks, very, I guess, Judge Guillaume, primordial interest of international law in the survival of states from nuclear weapons. And also the interest of not completely, not subjecting peoples to at least preserving minimum dignity and minimum human rights guarantees for peoples. And so that was perhaps sort of in more technical sense arguing that this would be consistent with the broader grain of the international legal order, that if states were to introduce it within the public international law bloodstream, so to speak, that would be consistent with the broader system. And the fact that, in a way, how Chile and Uganda have made those arguments sort of seems to be going in that direction, that perhaps there is a way of building up gradually and slowly state practice in that setting. So that, I think, is my claim. So one with many qualifications and many but. So this seems like an incongruous situation, but is one that reflects the considered judgment of the International Law Commission and the greatest minds on state responsibility, but based on assumptions that are no longer reflective of contemporary international law, but broadly endorsed by necessary implication by states, but capable nevertheless of being gradually modified through state practice. Let me just note in the very end a bit of a coda. As I said, the points that are not direct implications, but I think strike me as interesting nevertheless. The one I think was really I suppose, the basic truth and also the basic untruth of formalist positivist international legal process. That the description of the way how things played out in the ILC and afterwards is perfectly consistent with the way how one thinks about sources. International law ultimately rewarded those who spoke out at the right times, who were consistent and comparatively general in their practice, and punished those who were inconsistent and spoke out at the wrong times. So in that sense, precisely how international law should work. At the same time, if we look at those who did speak out and those who didn't speak out, there's a clear correlation that if states are capable of according material resources for public international law matters, if they are sophisticated players from P5 countries, they are more likely to be capable of taking advantage of these international law opportunities. Now, it doesn't mean that, I think that they are both true. And it also suggests to me, I think it's something that has really come up in my talks with states, the extent to which smaller actors can actively take into account the opportunities provided by the formalist legal process. So totally different substantive area, but one thing that has really struck me and that I have been incredibly impressed about is the extent to which small island developing states individually and collectively have managed to in many ways take control of the law-making process regarding sea level rise in the International Law Commission and in other settings. So these are things that might not be naturally playing in favor of actors who are not traditional great powers, but it's perfectly open to that. And so in that sense, I think that there's a promise of the universalist system. The final point that I want to make is fascinating, is really the presentism of international lawmaking. And I don't think it's impossible to get out of the fact that whenever international lawyers think about the natural order, as it were, the normal way of international law to operate, no matter how many times one might ridicule Whig view of history and Fukuyama, I don't think it's really possible to get out of the fact that present is the most likely frame of mind for the future. And the fact that it's really that the second half of 1990s, when investment law seemed to play no relevance at all for international law, when new international economic order was down and investor-state arbitration wasn't yet up, was the background that shaped the assumptions of international lawyers precisely when content of state responsibility was formed. I think that is something that really struck me as so clear. The present is a thing that informs our writing on the future and also informs our thinking about what has been valuable in the past. And I must say that when I was writing the paper, I was perhaps harsher in my judgment of the ILC because it seemed that investment arbitration was everything and other arguments were not really having much traction. But now, since the last 2 months, that we know that these are also very important arguments regarding war claims, something that ILC was thinking about because it had UN Compensation Commission in the background, it seems suddenly a slightly more sensible balance. So it's a, there's a claim, but there are also a few codas on the end that if anybody would like to pick up in the discussion, I would like to talk about. Thank you so much.
Thanks so much to you indeed. And at the same time, it shows very well that thinking about a topic is always an ongoing process. And even when we have completed a manuscript and we have this small, little lasting relief that we have completed something and we can, and yet I mean, it comes back to you, especially when you have put so much of yourself in this reflection. So I have no difficulty to imagine that you could put addenda to your article several times now and in the future, probably. I'm going to give the floor to Anne for her comments, and also just flag to the audience that questions are of course welcome. So do not hesitate to raise your hand and then to take the floor to ask question a bit later. So Anne would be really happy to listen to your comments.
Thank you, Helene, and thank you so much for inviting me to comment on this excellent paper and for your very kind introduction. And thanks to Martins for a paper which I think really deserves to be widely read, and hopefully also by state representatives and council. And I think it is really an exemplary piece of work. So it's hard to be critical on it. So this is not what I want to do. So I totally agree with the direction of the paper, and I think it's absolutely necessary that somebody is picking up that point and arguing it really well, and it is meticulously argued within the law. So there's no wishful thinking when you do your analysis, which I really enjoyed. It's strictly doctrinal in a way. But with a background, right? So you Martins, you wrote, it's a challenge for taking of granted doctrinal assumptions on their own terms. And that is something which I really like, because I think you do this really well. So you go through all the legal text, finding there's no rule against crippling compensation. You go through customary international law, finding that there's no rule against crippling compensation. You just extensively talked about the ILC, and you call for basically reconsidering the role of the ILC, and I think justly so. And you go through the general principles, again, finding that there's no rule against crippling compensation. And I'm not challenging any of this. So what I'm going to come to later is to give you maybe additional arguments which you could have argued. I'm aware of word limits of journals, so but still, maybe for future work, you might want to take that up. And then I think one thing which is important for the paper and obvious as well is your normative thrust in a way which I share, and I quote again, going from a self-interested interstate society to a common value-based international community to a legal order serving individuals as ultimate beneficiaries, quote end. And I think that is very important as an assumption. So you need to share this assumption and this view on the international legal order if you want to come to the same conclusions as Martin Paparinskis does. So as I said, the doctrinal work in the paper is done so well that I've really nothing much to add. I would like to give it some more general thoughts, including from a more theoretical perspective. So first from an institutional perspective, second from an international investment law doctrinal perspective here. So what I say really is only applicable to investment law, not generally, and your paper is generally treating crippling compensation in international law, even though, as you said in the beginning, your motivation was basically the investment law awards, right? And this is probably most in the discussion currently. And third, from an incentive perspective, and then I have some smaller comments which you might want to answer as well. So first to the institutional perspective, what I was always wondering, if the compensation is crippling, it's highly likely that the country will not pay. Like see Russia, for example, or Venezuela. And I'm asking myself how you situate that and how do you explain, given that if a court or a tribunal needs to or will calculate somehow, assuming they calculate whether their award will be complied with, what does it mean for the legitimacy of that institution if it won't be complied with? Highly likely not to be complied with. And for international courts, we have this sort of research. It seems that they somehow take into account the legitimacy when issuing their awards and their decisions. And why do then investment tribunals do not do this? And is this just really, again, the setup because arbitrators as such are not an institution? They're ad hoc. Should we assume that they care for the system? Should we assume that they do not care for the system? Or do they believe that countries for whom the compensation is crippling and who might not pay would not count anyhow in the view of other states concerning the legitimacy of the system as such? So would they care if, assuming they issue a $60 billion or $100 billion awards against the US? You could say, well, that's still not crippling for the US, but still you can assume they will not pay, like Russia will not pay the UCOS award. So would you believe they would take that into account? Whereas they would not take into account, you know, if it's against Venezuela, you know, nobody, you know, who are the countries which count in this legitimacy game? The second is a more doctrinal point, and that's more of a question actually. So what is the connection to legitimate expectations as used in investment law? And I know you're like concentrating on the damage awards, but there's a recent paper by Federico Ottino on the including public interest and legitimate expectations. That is one issue, but I think what is missing, so the point he basically makes that there are issues we need to take into account when we say what is a legitimate expectation, given that legitimate expectations are now like a catch-all thing in international investment arbitration. Isn't it? And that I was always wondering, and but long ago when the CMS award came out, I've argued it in German, so nobody reads it anyway, which is fine. But I'm still wondering why whether the question whether legitimate expectation can really be an objective standard in all countries alike. I know that's how they do it. Mostly the tribunals, I deem it thoroughly wrong, including from a business perspective. And indeed, you know, country risks needs to be taken into account and regularly is in business decisions. And one may even argue that the whole endeavor of having investment law is based on the acknowledgement of country risk. So when I look at the investor side, and they look at their country risks. They are supposed to look at least at the country risk, imagining that there wouldn't be any investment treaty, for example, they would self-insure. And that's what they are supposed to do if they are supposed to do good business judgment. But, you know, would you assume that you have the same legitimate expectations in Germany and say Somalia or Congo? Probably not. It's not an objective, cannot really be an objective standard. And if that is true, so you can either use it on the substantive law side, on the merits, so that would maybe give you a non-desirable all or nothing approach if you interpret fair and equitable treatment maybe, but should that not also enter the damage calculations? So can you really have a legitimate expectation of getting full reparation? I'm coming to full reparations in a second, in a country, let's say Germany and Somalia? Probably not. So can we not take it into account there? The next point here is, and it's probably easier to argue that case, so full compensation. And but what full compensation is actually is not entirely clear. So they always cite the Scharzoff. I hate this. I can't pronounce it. Scharzoff. But it doesn't tell us anything on how full compensation would be and ought to be calculated. Why does it speak to discounted cash flow method, which is basically expectation damage? And we compensate the plaintiff by giving him basically something he or she never had before, which leads to those super high damages. It's a discounted cash flow method. And why do we not take the reliance damages, that is recouping the costs for the investment made? And I just want to hint you to an article which I think is adorable by Lon Fuller and William Perdue in the Yale Law Journal 1936, reliance interest and contract damage. And what they stress, and I think that is important, we can only look at how we calculate damages when we look at the purpose of the body of law. And I think we need to go back to the purpose of the body of law when we decide whether we use discounted cash flow or whether we use reliance damage. I think that is maybe something to look at. And maybe you want to say some words on what you deem as the purpose of the international investment law, because that would lead to how you see that. And then let me turn a little bit to the incentives. And I when you go through the general principles, right, you look at things like existence minimum, like or the Japanese version of it, here, if it's correct that law is supposed to have a deterrent function or a preventive function, then it makes sense to look at municipal orders deal with different abilities to pay, right? And I haven't made a research on it, I admit, but I can only tell you for the Swiss and the German law, criminal law, if you get away with a monetary fine and you're not going into prison, then you will be fined according to your ability to pay. And that, from an incentive point of view, correctly discriminates between people in order to set the incentive rights. So a set fine might be crippling for some and just a dinner for somebody else, okay? So if we want to set the incentives right and equally for everybody, indeed we need to differentiate. And that calls for a rule against crippling compensation, because a 300 million damage award may be crippling for a small poor country, and setting the incentive for that country right, okay, not meaning that it's crippling, but giving them an incentive to act in accordance with the law, but that would do nothing, absolutely nothing, to deter a rich country, okay. Maybe a caveat here, this differentiation is used in public or criminal law, not contract law. So again, here, in order to make this argument, one would need to follow the shift you advocate from a bilateral to a community order. So that assumption needs to be taken into account. And then let me turn to some smaller remarks on the analogies you're looking at on sovereign debt, for example. I think what would have been useful here, because it reads a little bit as if you think, well, we don't really know what exactly and at one point that comes into play. But I think the discussion the World Bank had during the HIPIC initiative can serve as a benchmark. And of course, economists have developed criteria on unsustainability of debt. So that could actually give you a pretty clear line on at what point a compensation would be crippling. That could be taken into account by the tribunals, for example. Then I think I'm not in agreement that the closest analogy is the one to odious debts. Because odious debts, actually, this discussion targets unjust regimes, right? Having taken that to suppress their own people. But of course, the question of crippling is much broader. So it can be any regime, it can be a very democratic regime, which for whatever reason has its debt not sustainable, right? Or sufficiently sustainable. So you don't need the mala fide here. I would like to pressure you a little bit on that, and your sentence on page 25, there's no obvious systemic nudge comes from sovereign debt. I'm not so sure about that. So maybe you want to come back to that. And then maybe two more little questions. And since Hélène mentioned it in her kind introduction, I'm always interested in the psychological lens. And I wonder how you explain that states and council are not raising the issue of crippling compensation. Is this just past dependency? And then lawyers just look at what other eminent jurists have written, and then we feel we cannot deviate from it, and it would be unpermissible to deviate or go against the authoritative statement of the ILC. But then, you know, those what I call living lies or living myth in international investment law, the compensation issue is not the only one. Like what I always loved is this argument, I mean, laughing like that it's said, with James and others, you know, foreign investors deserve more protection because they cannot vote. And I'm just like, excuse me, business cannot vote anyway, it's citizens, but we are talking about business corporations here. And if you look at the plenty of research being done on lobbying by business and foreign companies, there's plenty. So where does this living myth come from? And then one tribunal after the other is repeating it. And I'm always asking myself, what is it in those tribunals? And I don't want to talk about this whole issue. We are debating who is on the arbitration tribunals, and you know, but how can it be that we have this sort of path dependency which nobody seems to question? And hopefully now, when somebody has spoken out loudly, as you do, Martins, with your article, maybe that changes. I'm not quite sure. Then the other question is, you deem it most likely that the prohibition of crippling compensation, the crippling compensation will be here with us to stay, right? And I was asking myself, so if that is correct, would you think that there is a return or maybe a turn to more what I call primary settlements, primary remedies? And you find this somehow, and I think the most illuminating case is the first Vattenfall case against Germany. That was an over $1 billion case. They settled the case. But if you look at as I read the settlement, it basically was a primary remedy for Vattenfall. They gave Vattenfall what it wanted originally, right? So if we cannot deal with the crippling compensation problems through damages, could we do that in settlements, or even in depending on what they want, going back to primary remedies, so to speak? Okay. And yeah, I think I stop here. I think what you said now in your talk, which I liked at the very end, is this critique of this factual inequality of states who are hurt, even including in the ILC, and this small state alliance on the sea level rise. Would that be a way forward in that? Because I feel we have so many instances in that. We had it on the question of the permissibility of unilateral sanctions. There were so many states speaking out against it, and nobody listened, basically, right? So it seems that there's such a de facto unequal voice between some states and others, that alliances are the only way forward. And the question is, how do we get there? How do we really get there? And now I could come on with another social science theories on the logic of collective action and under what circumstances it works or doesn't work. I'm gonna stop here though, and maybe you have some ideas on the issues I've raised. But thanks again for what I think is an article of great importance and wonderfully written. And thanks so much, Martins.
Right. Well, thanks, Anne. That was fascinating, and I think perhaps no good deed can remain unpunished. So I think I will be sending you my articles for feedback for the future. Let me just pick on a number of points. But I mean, I think even if I do not mention something, all of them have been duly noted and extremely helpful. The first point that you raised was about the concerns about compliance and how that might feed into perceptions of institutional legitimacy. And I think I would be inclined to, I suppose, to derive the function of the adjudicator and their perception of the role in a rather formalist way from the manner in which the particular institutions have been articulated. So at one end of the spectrum, one might have standing institutions with a standing secretariat embedded within a particular international organization, within a particular political community, with more or less formalized, as it were, feedback mechanisms and continuity. And we might be thinking here about the role of the International Court of Justice in the United Nations, or European Court of Human Rights in the Council of Europe, or the World Trade Organization's dispute settlement mechanisms within the dispute settlement body. And at the other end of the spectrum, we have fields with no political institutions to which the bodies would be turned, no standing substantive secretariats, and in dispute settlement institutions were blinking in and out of existence and becoming functus officio. And I think it must be the case that the closer that we get to the second end, the less there would be in terms of institutional incentives for individual blinking lights to be concerned about the system. So I think I'm probably more sympathetic to those tribunals and scholars who are comfortable with a fairly limited sense of judicial function in investor-state arbitration settlement, because that seems to me to capture best the limited institutional connections that are there. And for this particular purpose, it would strip the argument of taking into account for institutional legitimacy. So I think, in a very broad brush terms, if one wanted to have an institution that does not care majorly about the compliance effects, one would come up with something like investor-state arbitration. Now, can we articulate these concerns at other levels of the legal argument? For example, on the primary rules, where the capacity would already be articulated at the level of determination of compliance. And plainly, that is something that international law is comfortable with as a general proposition. We know fields of international law that speak about common and differentiated responsibilities. It is something that we can articulate through vague formulation of primary rules. I think many rules on protection, for example, are drafted in a way that takes into account capacity. And I think within investment law, for protection and security would be the example where capacity would be taken into account as one element. I think fair and equitable treatment is, you're right, a slightly trickier animal. And it's also a bit hard to sometimes grasp the nettle of what formula or combination of things is the one that captures the nebulous meaning most. Again, I think I'm a bit partial to the points that a few of tribunals chaired in the last few years by Judge Crawford have made, that perhaps expectations are better viewed as considerata in the application of a vague rule, rather than forming a core legal standard. And if that is the way how we think about it, there could be greater scope for taking into account a variety of considerations, including the public goods pursuit and the capacity of addressing things through other considerations. I mean, I must say that it's, I'm writing a book for OUP in the Elements of International Law series, and just now really sort of thinking through analytically of how to generalize about what fair and equitable treatment stands for, looking at it through the lenses of authoritative treaties in various settings, which do not seem to be easily compatible was the thrust of some of the case law. So there are certainly interesting legal questions at that level. Now, if we go to the question of full reparation and compensation, yes, I think one way of tackling would be to do it one step earlier and to look at the valuation methods. I mean, I guess it is perhaps. I think again, I think I was probably trying to frame it very honestly. I think there are probably lots of jokes about the point that, you know, that if I wanted to, you know, that somebody asking somebody else, how do I get to London? And, you know, if I wanted to go to London, I wouldn't start here. But if we have to start here, if we are in a situation where multi-billion claims are routinely awarded, it might be that going back and rethinking DCF and valuation is a bit that has already been passed. The question is, how do we address a situation where things will arise also at this stage, things that will not be addressed through bigger institutional structures or through valuation, but that will come up with a certain number. And I think sort of the one thing that I was thinking about really in terms of systemic balance, one thing that Crawford did not mention explicitly, but that I think is consistent with the broader philosophy of his third report in the ILC, is the implicit assumption. The very clear skepticism of the third report and the ILC commentaries about DCF, about compound interest, the two elements that are proxies for the large numbers. Now, and I think that there could be sort of two responses. One response could be, all right, well, that might mean that we have to look more critically at DCF, which is not that I'm not criticizing that is a perfectly, you know, valid way of approaching the issue. Another way in terms of systemic balance would be to say, well, there's a certain logic, as it were, a certain legal equilibrium that the ILC was thinking about, and to the extent that there are things being developed that disrupt that equilibrium more in the direction of the injured actor, it makes sense systemically for a slight gap to open there to insert a principle that balances it back to the middle through the crippling element. So, you know, you can address crippling things by simply, as it were, staying where the 2001 articles were and not having DCF, or if you have DCF, you balance it back in these terms. And they are not necessarily exclusionary articles, that there have been a number of very interesting pieces. I mean, I think really literally in the last few months by M. Eisbeth, Jonathan Bonicta, and a few others who have raised these points. So it's sort of, I'm not at all dismissing that is a valid way of thinking about it. So I think then there's a question of, and I think that goes to both to, so the question about the purpose of the regime, what is the purpose that is being pursued here? And that is, I suppose, the question the question is whether one should be thinking here, as it were, I guess, whether we can answer the question by being fully faithful to Aggo Crawford type of thinking. Primary rules on the right side, secondary rules on the left side. We'll look at the left side without really looking at the right side, which of course we know that there are many overlaps and influences, but in analytical terms, that would be that. Now, one response could be to say that investment arbitration is a slightly odd animal. Article 33.2 of the ILC articles leaves that without prejudice possibility that there may be different fields there. Now, I think if we look at the level of secondary rules, because they are so, I think, dehydrated of any touch with the reality, that they are equally attuned to war crimes, social rights in regional setting, and investment law, that it's not easy to go in excessive detail about purposes, because they would be more naturally tied with the regimes and institutions within within primary rules. And I think that is sort of, it is a bit of my judgment call of where I think investment law is at the moment. I wrote an article about 10 years ago in the European Journal where I, with apologies for being self-referential here, but the point that I was trying to make then is, well, isn't this odd and surprising that you see all these references in tribunal awards to ILC articles, even though technically speaking, they are irrelevant. At most, they are without prejudice to investor-state arbitration. And there have been a few arguments here and there raised about it, but I think, again, the core of practice seems to me to have been accepted their broad applicability in both settings. To the extent that we see state practice, however carefully in treaties, there is discussion of compensation, restitution, and how they apply, but they are not crafting them, as it were, from the ground up as lex specialis, but they seem to be rather accepting the general principle and then perhaps tweaking the application. And the sheer routineness of invocation and application in investment tribunal awards, I think that this is kind of really going back. Is it something that states are challenging? Are states pushing back against it? And there may be, I think I'll come to the psychological question of why they are not doing that in a little bit, but for the formless legal process, they seem to me to be at the moment resigned. So again, there was a battle and question to be had. If 20 years ago from CME onwards, every state said ILC articles are irrelevant, let's think about crafting a regime that is attuned to the purposes of this particular primary regime. We might be in a different place, but we are not in that different place. I am in complete agreement, and I think billion is here just a nice round number. Of course, a billion is a different thing for United States and China, and for a small, least developed state. And I think it's interesting that one of the recent decisions that mentioned in a very different context, crippling compensation, is the dissenting opinion by Judge Kateka in the Dusget integrity case, a small interstate law of the sea dispute where I think the award was for less than $20 million. And that is something that I think that is absolutely right if we are thinking about incentives. This is obviously has to go back to the capacities. But then that again goes back to the question of whether we can articulate broader purposes, sort of what is the incentive of secondary rules as a category without being attuned to primary rules. I think I want to say perhaps one sort of more general point about ICSID review system and the way how that might privilege a more formalist approach to these matters, that there may be other settings where courts may be getting away with more things. And it's really the fact that it seems that if we look at the kind of the big or small annulment challenges that have been successful in the last 10 years, there is a great, to the extent that as a general matter, we assume that people prefer not to be humiliated to be humiliated. And if we assume that being set aside is not the greatest thing that could ever happen to an arbitrator, there would be an incentive for tribunals to write their awards so that they are not set aside. And if we look at annulment decisions, what strikes me is that, in the first decade, so to speak, we had people set aside on the very basic first part of ILC article grounds, Vivendi and Argentina and such. And then in the last decade, we have people mostly being set aside precisely on these small technical things. Casado 1, Tidewater, Occidental, just a few weeks, Perenco and Ecuador. There is a great deal of an incentive for tribunals not to deviate from their path, or at least to deviate in a way that could be plausibly defensible at the annulment committee level as something where reasonable people could disagree. And that was a little bit of my thinking as well about framing my argument for exception. This is something that is just one sliver next to the mainstream, and that if we have 10 states arguing for it, we are already getting in a stage where a tribunal might say, well, you know, that might not be my first preference, but it's not mad. And things not being mad seems to be something that is good for a legal argument to be in investment arbitration setting. Let me just jump. I think I have taken note of the sovereign debt point. I think that is probably something I'll have to think through. That was extremely helpful. But I just want to say a few things about the psychological questions. I also have had a pleasure of talking with some of the people who have argued some of these cases or maybe arguing some of these cases. And there seem to be a number of considerations. Now, there is, there is probably the kind of the David Caron point that ILC articles are just so wonderful. And they read so clearly, and they have been written by such smart people. And so we do not want to go beyond them. And if we go beyond them, then if one would have had Judge Crawford or the disciples in the annulment committee, there would be the awkwardness of being set aside or chastised, and nobody wants that. But I think that there are also better arguments as well. So there is the argument that if you don't want to be specific about what is crippling, because by that you are necessarily indicating what is not crippling. And you don't want, if you are arguing against a $6 billion claim, you want to end up at a $0 award. You do not want to indicate a comfortable landing zone of saying, well, 6 billion is a bit much, but 3 billion is something that we could live with. Because you want to fight it all. You do not want to, and I think that is one the point by an experienced state counsel, to say that, well, if we did argue that, presumably we would have to show that we do not have assets. We would have to show that these are the assets that we have, these are the assets that we have here, these are the assets that we have abroad. And therefore you are providing the investor with a go-to list of where they can find your assets. So there are other practical considerations there. There are, I think, also, and I think that is something that is harder to test, but anecdotally, the point that sometimes it's better to have a strong policy argument than a weak legal one. Tribunals are not fools. They appreciate that we might not have all these multiple billions. If we convert it into a legal argument, as we know from Martin's article, it's a little bit of an out there legal argument. So perhaps it's better to keep it as a general policy framing rather than a weak legal argument, and if it's rejected, it's rejected. And then there's also, I think, kind of probably the social science collective action thing. If we had a rule like that, we would all benefit from it. But if we were the first ones to present it, we would look a bit awkward. It might, the tribunal might get a sense that we're overall raising trivial, frivolous arguments, and that might undermine us. So we are very happy to be the person who makes the argument, as long as we are not the first 10 people to make that argument. And because somebody else would have to make it, then nobody are the first 10 people to make that argument. Therefore, nobody ever makes that argument. I think there's a mixture. Some are better, some are worse, and I do wonder whether anybody is, I guess, really putting these things into arguments right now. Probably something that we'll just see in a few years. I mean, again, thank you so much.
Thank you very much for this, your very rich answers. Indeed, I mean, it has already been noticed that doctrine in general is not very much cited except for a few names, but nevertheless, a few names are quoted in, especially in footnotes. So we'll see if your article finds its way. It has already been cited, and so I mean, it has had a very early celebrity. But I guess Anne would like to answer, and I would add to the psychological question, nevertheless, a question I had. Indeed, states do not raise the argument of crippling compensation. Is it also because it may have a deterrent effect on other investors, or which could be an additional factor? This is not an argument that they might be ready to discuss it in general, but not with regard to their own situation, because it would be like confessing that they are not able to pay so openly. So I was just wondering whether it was part of the psychological argument also. So,
I mean, I think that seems like a plausible assumption that there could be different constituencies domestically and internationally. And in the Tetyan Copper case, for example, one of the things that was considered, discussed, I think it came up in the discussion of the stay of enforcement decision by the annulment committee, the question of whether the award might have some effects on the relationships with the IMF that had recently provided a large credit to Pakistan. And I think in some settings, it does seem to me that there could be the investment point. I think possibly in some other fields of primary rules, there could be also unwillingness to communicate to some particular groups that could be affected either internally or externally. So so there could be arguments not directly related to the legal merits, but in a way that is not unusual for international law. We are familiar with the proposition that on any points, the ability to be very clear is affected by myriad of considerations, friendly relations with particular states or organizations. So in that sense, it's right, but it's not peculiar to this.
Yes. Anne, would you like now to?
yeah, just to come in. Thanks, Martins, for your answers. I would like to follow up on one point you make, that there might be a fear that they need to show assets, basically a to-go list for the enforcement. I think that is not necessary, and I think I was always struck by the reference to the IMF in WTO law. You have it in each agreement, their balance of payment problems, for example. So there is an assumption, at least in trade treaties, that you would look at the situation of the country and whether they have to comply or not. And you would rely on the advice of the international organization dealing with balance of payment problems, debt, stuff like that. So why has that not been the case in investment law? And I mean, maybe they should have just put it in the treaties, which they didn't. But what you could still do is basically saying, well, this is where you need to look at, and that you don't need to show every asset a state had. That would be even, I mean, not only for fear of giving them a list for enforcement, but just it's unpractical. You won't be able to, I mean, you won't do this. But the IMF has assessments of those countries, and they can tell you where they are, and this is even public information. So that comes back to your question, Hélène, would it have a deterrent effect on other investors? This is all public knowledge. I mean, investors, a diligent investor, they buy all the data and all the information, be it from Bloomberg, from other country risk assessment agencies, and they know. So the only thing which could happen is that you have a crippling compensation award of, let's say, 10 billion. And then you say, oh my God, now this country is bust. I'm going to get out of it. Or I revise my decision to go into it. Okay, so I would rather argue the reverse. I don't think that diligent investors do their job anyway. If they're not diligent, sorry, then they lose their money. I'm fine with that. you know, there's something like good business judgment, which actually should be taken into account by the tribunals, but almost never is, probably because the lawyers think they cannot adjudicate on good business judgment, but they can adjudicate on IMF advice, like in Argentinian case, whether there were other economic measures the country could have taken. So they put themselves into the shoes of an economic minister, but they do not put themselves into the shoes of a businessman. That is problematic. Sorry to be so outspoken.
No, it's not. I don't think it's completely out of scope. I don't know whether Martins would like to answer. I also flagged that you have some questions in the Q&A that I think you can see the questions. I can read them, of course, but at the same time, if you read them directly, it might be more practical if you would like to have a look at them. But I can read them. But maybe you want to answer Anne first, as you wish.
Yes, I think I would have to. I would have to reflect upon it. I mean, I think so. I mean, I suppose one of the advantages. So I think I have been making the point about the disadvantages of being the first mover on this. I think one of the advantages for the first mover in a field that there's quite a lot of practice flying around with different emphases, that would be to frame the debate, because one couldn't really say that there's one way of approaching this. I think probably the closest that international law got to it was in the Sokobel case of the PCIJ, and that was settled on other grounds. And so I think they said that they would just really ask experts to advise on the matter. I think it's really sort of a question about the institutional framing and the extent to which one could address it, whether through sort of the non-disputing party submissions or otherwise. I think there could be some interesting questions of institutional cooperation, but it's certainly a perfectly plausible way of looking at it. I would be happy to read out. I think that would indeed be most efficient. Would you be happy for me to name the person's name, or?
Sorry, as you wish, or I can do it. You have a question from Somesh Dutta, and we'll ask whether your opinion regarding categorizing inherent powers of adjudicators as a general principle, because in your article, there is a section on general principles. And would you consider inherent powers as a general principle, and could it pave the way for considering crippling compensation aspects in light of the treaty standard of full compensation?
So I have written a bit on inherent powers, and probably I do not think that we really even need to get to general principles to get to think about inherent powers. It is perhaps more one particular example of application of the general idea of ordinary special meaning, that if there are certain bodies within international law, if they are called adjudicators, then they come with a certain list of rights and functions, which may be set out explicitly, but if they are implicit, they still have them. I think that possibly what the question is getting at is the interesting question of whether this is something that tribunals should be, as it were, raising themselves, even if no party is raising them. And that is an interesting question. There's, of course, very rich and sophisticated practice in international law about the tension on the triangle between Jure Novit Curia, the ultra petite, infra petite, and sort of various due process considerations. It's worth noting that in the Eritrea-Ethiopia Claims Commission, the one institution that did accept the point in principle, this was something that was raised completely proprio motu by the commission. Something that both parties were making very large multi-billion claims, and the commission on its own consider the point. So that I think is an interesting question to consider. Again, I would imagine that tribunals would be thinking about the annulment committee and how to balance not manifestly exceeding the powers and being respectful of breaches of procedural rights. I mean, I think that's probably the way how I would think about it, is that if we think about the broader multilateral interests, I mean, in the 21st century, I don't think it would be an outrageous proposition to think that there is a general interest of the international community in the survival of states and their peoples as the basic building blocks, and that this is an interest that should be reflected in all international judicial bodies. Obviously, not deciding on things that are not argued or pushed for, but at the very least raising it as a point of principle. So that is the way how I would think about, and that could indeed go back to the inherent powers. But I don't think that I think it's rather a straightforward proposition in my view.
Thank you very much. I think you were on the same page as the author of the question, who approved the context in which you put the issue. You have a question from Kong, who asked whether the notion of crippling compensation creep into domestic legal system. Has it crept into domestic legal regime, in particular during enforcement stage? And suggest as example the pending English court decision in P&ID versus Nigeria, and Nigeria's attempt to set aside the arbitral award of $6.6 billion US.
Yes, I think that it is plainly an excellent question. And particularly if we think about investor-state arbitration, although I think that the Nigerian case is a slightly peculiar one in that there is a contract-based arbitration, if my recollection is correct. But if we think about investor-state arbitration, then of course we know that to the extent that they are not exit cases, they are in principle subject to the review jurisdiction of the seat, and there are quite a few examples. In France, particularly in recent years, but also in other countries where they have been set aside. So I think that would probably be a question of, I suppose, a reflection of whether there are ordre public or arbitrability arguments that might be raised. Then, of course, I suppose, a bigger question about the incentives that domestic courts might have in these settings and how arbitration friendliness would be compatible with essentially looking at the merits. Again, I think Nigerian case is a bit peculiar because the challenges are on ground of corruption. So the size of the award is slightly incidental. I think that there's also sort of a question of whether there could be scope for states to articulate their concerns in terms of circumstances precluding wrongfulness, because that was one point that the International Law Commission mentioned, that possibly if there is a ginormous award, that force majeure or necessity could be an argument for at least delaying its compliance. And that, I think, is again a sort of more of a question for domestic law and domestic legal traditions. I mean, I don't think there are too many examples, but I mean, there was the German Constitutional Court case now quite a few years ago in the Argentinian context, where necessity did not get too far, and there has been a case in the English courts where Ukraine argued countermeasures in relation to Russian bonds, but again, somewhat inconclusively. So I think it's certainly a very interesting direction to look at. I'm not sure whether it has the answers, but it may be that my thinking about it hasn't been complete.
Thank you. Harrison Borey was one of the researchers of the Institute and played the devil's advocate when we spoke about your article. As mentioned that recently, Chimney has argued that articles on state responsibility overlooks the distinction between secondary and primary rules. And the assumption is that secondary rules are value neutral and therefore cannot be unfair to weak states. So do you agree with this? And how does this fit into your case against crippling compensation?
Thank you, Harrison. Let me just first say that I'm completely in agreement that Professor Chimney's recent EGIL article is an absolute must-read on the topic. I think I probably disagree with one, I think really in a rather factual sense, because one of the points that Professor Chimney made was that the ILC members from the developing states missed the implications of the second part. And I think, at least on my reading of the discussions in 1990, that seems not to be the case. So two future judges of the International Court, Judge Shea and Judge Benuna, were very explicit about the implications of compensation, particularly in investment claims. And so I think that kind of again goes to the point of that that states have to actively partake of the lawmaking discussions. ILC was attuned to these matters. States, to a very significant extent, were not. Now, one answer that was given by both Aranjo Ruiz and Crawford, the two rapporteurs, was that, look, this is just secondary rules. If you have a problem with these things, go to primary rules. And Aranjo Ruiz was giving the examples from trade law and environmental law and law of the sea, so the common and differentiated responsibility. Secondary rules do not exclude that. So I think that Professor Chimney's argument sort of goes in the same direction, to the extent that he raises other reasons also from trial perspective why one might be sympathetic to the to a rethinking and to having a rule on crippling compensation. Although I think that, again, I mean, so probably at the doctrinal level, we would still want to see in the end states actually picking up that argument and running with it. So I think it may be that we're arguing for slightly different conclusions. I would be interested in a conclusion that materially changes the law. One thing that struck me, though, when I was reading Professor Chimney's article, and that perhaps brings out the point more clearly, was a possible counter-argument. So the question is whether, from a trial perspective, one should be favorably inclined towards creation of foundational rules, so not primary level rules, not institutional rules, but level at the foundational constitutional level that recognize different categories of states, so that would have different rules for developing states at foundational level. To recall the primordial importance of the principle of sovereign equality of states, something that, you know, in the whole great powers and outlaw states spirit has been very influentially historically used by the great powers from Europe, something that developing decolonized states during the Friendly Principles Declaration were incredibly insistent upon. So the principles of sovereign equality, on the basis of which permanent sovereignty and new international economic order were built. So I wonder whether there could be a sort of a zero-sum game almost, that we can have either an international legal order that is at the foundational level very attuned to differences of states, unequal treaties, broad special rules on compensation against developing states, but possibly with the effect of pushing and weakening sovereign equality, or being strong on sovereign equality, no unequal treaties, as in the Vienna Convention, and being sensitive on these matters at the political level, at the primary rules, in a way of saying the system will not do the job for us. It is something at the level of politics and rulemaking. And so that is sort of, that was for me a question mark, whether if we go too far at the foundational level where we may be indirectly undermining the importance of sovereign equality, which I don't think should ever be taken as a given, particularly nowadays.
Thank you. I think it's still open to discussion if I know Harrison well. However, he got an answer. Sadra Pirniakan asked whether could the second category of general principles of law as mentioned by the ILC Special Rapporteur be useful in the future of this matter through incorporation via General Assembly resolutions by developing countries, for example?
Yes, so I think that you are absolutely right. So I think that the reference is what is currently being discussed. The first category would be the more classic building general principles from shared domestic legal traditions, and the second one is perhaps a little bit more controversial, deriving from the international community itself. So, I mean, I think that these are not, we could get at these points sort of, and again, I think that the sea level rise is an absolutely fascinating case study of states using very consciously the cutting edge international arguments through regional custom and institutional law debating to build a momentum. I don't think that there is need really just to focus specifically on general principles. It's also could be partially a way of generating general principles, partially as a place for articulating state practice. And there are a lot of places where that can be done. Every 3 years, the Sixth Committee is looking at state responsibility. So for the next time, I think in 22. So that is a setting where states can express their views on state responsibility. UNCITRAL is, as we know, looking at investment treaty reform with a rather narrow focus, but also something that is at the edges looking at compensation. International Law Commission, not to be self-referential, but one of the topics that is on the long-term program is compensation under international law. Something that has been identified by the Secretariat as one of the topics where there is a considerable amount of practice, particularly in the last 20 years, and that it may be worth looking at that in greater detail. Now, as far as I'm aware, none of the current ILC members has expressed a particular interest in spearheading that project, so possibly there could be some candidates who, if elected, would be interested in pursuing that. So that is also a consideration that states could engage with. So I'll guess probably as outrageous as one can be. I think that will probably.
Yeah, let's see what happens. Indeed, I mean, this is a big topic, and at the same time, states are so reluctant to grave anything in marble regarding international responsibility. As the recent German compensation to Namibia shows it again. So. We still have 2 questions, one coming through the Q&A and the other one through the chat. One from Tatiana Reynaud, who thanks you for the very interesting presentation and for the great discussion. But Tatiana is concerned about the potential obstacles in practice to a case against crippling compensation. And she asked whether the estoppel clean hands doctrine could be a bar to arguments against crippling compensation, for example, endemic corruption.
That is an excellent question. I think it's, so I think, and it is only actually, I think perhaps just to be very honest about the other side of it, it is one of many, many practical points that might be raised against crippling compensation. So really in a very practical case, since a state as Venezuela, for example, in the last few years may be facing multiple multi-billion claims in parallel. Some of them in the relative publicity of ICSID, others in UNCITRAL, argued by different council teams, heard by different arbitrators, proceeding at different paces, very, very hard questions of how for any tribunal or any council team to frame it so as to being sensitive to sort of the bigger questions. So in a way, I guess perhaps in some ways the flip side of the discussion that investment law had 15 years ago, when there were many, many claims against Argentina, and it seemed that the first few might be successful and the final ones, even if successful, there would be no money cover it. Extraordinarily hard, and something that is again something that a mass claims procedure might be able to deal with, but investor-state arbitration, more individualistic sense, could not. I think I'm probably a little bit less concerned about the specific points raised, important as they are. If anything, I would think, as we have seen in practice, that arguments about sort of corruption, if I understand the framing of the question correctly, are likely to stop the case fully in its tracks. So in a sense, one would not really even get to the problematic point. So I think that the way how I understood the question was whether there could be a concern of compensation being crippling, at the same time the state's conduct being very problematic. Whether there's a sort of a way of weighing one thing against the other. Yes, I mean, I appreciate where that is coming from. I think that I'm not sure whether that would, as it were, where that there would be addressed at different stages and at different analytical levels, and would not necessarily stand one against the other, at least the way how they are usually applied in practice.
I think it corresponded exactly to the understanding of the author of the question, but indeed, in this kind of question, deserve to be asked. I mean, if you compare to what happens in other fields, you find that exactly the same kind of issues. For example, in WTO, if a state would like to benefit of an exception, you say no, but because contraband and smuggling is such that at the end of the day, you cannot say that your practice is in line with the requirement to benefit of an exception. And so this is the same kind of question, and Anne also would like to intervene.
Yeah, I found it a very interesting question. I really understood it a question to be, I mean, not legally speaking, it's again an incentive question, and that's basically the question whether you would not set wrong incentives for a state which is highly corrupt to plead for this, at least partial setting aside because of the crippling compensation. And I think it goes along the necessity lines in Article 25. So has the state contributed to its situation, and that's a moral hazard issue which is dealt here in the law. I just think is if you do like Martin's basically asking, well, we have this problem here, and it's a question of whether we can unburden the state from that time on. I don't think that the moral hazard problem might be there, but honestly, we usually disregard it in international law on those questions because we disregard who is in the government, right? We disregard it when we, in so many instances. I think if the corruption can come in this very specific case which you're adjudicating, and then if it's at least too blunt, it would usually be taken up by the tribunals, as we have seen. But if it's a general high level of corruption, it doesn't matter really for the behavior for that specific case. So I hope I understood the question correctly in that regard.
If I could just add very briefly, I think if So I think the point that struck me along those lines is that, so I think that there is probably again the question of whether we are debating it regarding state responsibility more generally, regarding everything, or more in the investment field. Because if we have to craft something that would be so as it were reflective of all the equities, so I think that there's, if we, so for example, in the arrest warrant case, sorry, not the arrest warrant, the armed activities on the territory of the Congo case, there's a very interesting, question about sort of the broader institutional purposes and incentives between my colleague Philippe Sands for the RC and Alain Pellet for Congo. And Philippe's argument was that, well, if you do not grant a substantial compensation, that will be a blow to the reputation of the International Court of Justice and the broader purposes of maintenance of international peace and security in the region, or more generally. And then the Alain Pellet's sort of objection was that, look, there are all these good things that Uganda is doing in the region, and if we have to transfer, a very significant part of our yearly budget, that will have knock-on effects here and elsewhere. And then if we add I suppose really the res judicata binding effect on the important breaches of international law, I think that they are very hard. I think there was a bit of that in the ILC's discussion on restitution, of almost sort of saying that, look, if what is impossibility, what is disproportionality, if somebody has to suffer untold consequences, should that be the response? If the awful ill has to fall somewhere, should it fall on the responsible actor or on the injured actor? And I think that's really the contribution point. Is certainly something I think that when I have been discussing with practitioners in investment law, kind of the discussion of cases like Venezuela and Egypt and Pakistan, I think the one theme that has come up is that it may be that if there's a general perception that policy choices of one country have contributed to its economic ills, that should be a bit of a consideration taken into account. Now, obviously, practitioner community is not coterminous with the international lawyers community on this issue, but that is something that struck me as a recurring point.
Thank you very much. We're running out of time, and we still have two questions left that I will ask from Marina Trindade, who thanks you for the excellent discussion and would like to ask if you could see the full compensation principle arising out in customary international law, the Chorso factory, so it's with my accent this time, and Chorso factory, and reflected in the ILC articles being applied to indirect expropriation if it is deemed unlawful. Whether there would be a differentiation considering the challenges in indirect expropriation in identifying the element of breach of an international obligation.
Thank you. That is an excellent question. My pronunciation is, if for anything that matters, is Chorzów. I understand it's Chorzów factory, but I think again this is a bit of a movable feast. I think that there is. I think that the question is right to point to the difficulty, and I think probably in methodological terms one could say, well, if it's a wrongful act, it's wrongful as any other. At the same time, I mean, I think that probably the two footnotes that I would add here, one is that perhaps it's important to look at the precise issue of breach and causality and loss, that there is, there may be a bigger damage caused, but if only it is caused by the particular breach, there's a difference in unlawfulness between things being discriminatory or just, a notice not being sent. So we have to, I think, to be clear on what the breach is. The second one is that this is, of course, something that states can look at if they are interested in their treaty drafting. And one thing that I found very interesting in the Dutch recent model BIT in that they say that the same rule on compensation apply whether or not the expropriation is lawful. So in a way, what they are presumably saying that this is a lex specialis, special rule. So we are not we never get into horsehoof. We always stay within the rule as it is reflected in the particular thing. And perhaps that is the most straightforward way of getting at it, just kind of having a special rule on that. Of course, that doesn't address crippling compensation, but at least that kind of gets us out of custom.
Thank you very much. And the last question we are able to take today, but we see that the discussion is far from being exhausted, comes from Dominique Ornick, who enjoyed a lot the discussion and revert to the analogy to sovereign debt and the fact that the claims cannot always be effectively enforced. Do you think we should rather focus on payment modalities instead of limiting the principle to avoid compensation becoming crippling? Is this exclusively a matter of enforcement?
Thank you, Dominic. And so I think the question that you ask is probably the way how ILC thinks about it, or at least thought about it in 2001. Compensation is a figure on a paper. We know from Article 50, was it 1B, that you cannot use countermeasures in breach of fundamental human rights. So this is, I think, perhaps the balance that ILC is getting at there. Well, you can come up with a number, but you cannot be forcible when enforcing it. So in a way, one can say things that we are usually a bit, well, I wouldn't want to say we at least, but there's a sort of, always the undergraduate who says, well, where is the international law bailiff? What happens if somebody breaches international law? Perhaps that is the answer. It's fantastic that there is no international law bailiff and that we can be perhaps more flexible in expecting negotiations where states have their breathing space. Now, I guess the question is whether New York Convention, Exit Convention is a real bailiff, and therefore we have to get to the question before it gets to enforcement. And that would be my argument. I think that it cannot really be realistically addressed elsewhere. It cannot be addressed earlier and it cannot be addressed later. So it's kind of like a Goldilocks point. It has to be addressed precisely then. Thank you.
I think it is for us to thank you for this very, very rich discussion. So Martins and Anne, for your exchanges, very extensive answers to any question. And so I think it is very striking for the audience how well you know all the details and the specifics. And it also shows, and I think it's important, especially for the young researchers listening to you, that every angle of your topic has been explored and very much in depth, going to the primary documents. So thank you very much for all this, the presentation, the answers to the question. Thanks very much to Anne for having teased you with a lot of questions. She said that she would not challenge you, but at the end of the day, many of her questions were quite challenging. And I think it was also a strong incentive to the audience to come with also challenging questions. Thank you very much to all of you. This webinar was indeed a big success, and congratulations again for this article. And now we will all be longing for Crippling Compensation second season, if I understand well. We might expect a return. Thank you very much. And we do not have the emoji to upload you, so in the name of the audience, I upload both of you, and especially of course Martins, and for all the work you've done, and for this webinar, and being the guest of the Max Planck Institute Luxembourg today. Thank you, and bye bye to everyone, and to all our attendees.